13-1-0133, State of Hawaii versus Stephen Capobianco, jury trial.
Good morning. The record will reflect the presence of counsel for the parties. The defendant is present, and we're ready to proceed with this phase of the trial. At this time, we'll have the jurors brought into the courtroom. That will include our alternate jurors, our remaining two alternate jurors. The record will reflect the presence of the members of the jury. And good morning, ladies and gentlemen. Counsel, you may be seated. Mr. Capobianco, you may be seated. Thank you. All right, ladies and gentlemen, we're now at the stage of the proceedings where I'll be, during this phase, reading instructions of the law to you. After that, I'll give the attorneys the opportunity to present their closing arguments with respect to this. Each juror should have a set of instructions. If you do not have a set of instructions, would you please raise your hand? The record will reflect that no one is so indicated. I'll give you a chance to just get organized. I see a few are just getting your papers together, so we'll just wait a few moments while that occurs, and then I'll start reading the instructions. All right, it looks like everyone's ready. All right, very good. All right, then I will begin reading the instructions. Instruction number 1. Members of the jury, the purpose of this phase of the trial is to determine whether the prosecution has proven beyond a reasonable doubt that the murder in the second degree of Carly Scott by defendant Stephen N. Capobianco was especially heinous, atrocious, or cruel, manifesting exceptional depravity. During this phase of the trial, the court will read its jury instructions to you. The prosecution and defense will then have an opportunity to give closing arguments. After closing arguments, you will begin your deliberations to answer a question which will be provided to you on a special interrogatory form. In answering this question, you are to consider the evidence that was presented to you during the trial in this case. Instruction number 2. The court will instruct you now concerning the law which you must follow in arriving at your decision. You are the exclusive judges of the facts of this case. However, you must follow these instructions even though you may have opinions to the contrary. You must consider all of the instructions as a whole and consider each instruction in the light of all of the others. Do not single out any word, phrase, sentence, or instruction and ignore the others. Do not give greater emphasis to any word, phrase, sentence, or instruction simply because it is repeated in these instructions. Instruction number 3. For the purpose of this phase of the trial, the law requires that the prosecution prove beyond a reasonable doubt that the murder in the second degree of Carly Scott by defendant Stephen N. Capobianco was especially heinous, atrocious, or cruel, manifesting exceptional depravity. You must presume the defendant innocent of this allegation against him. This presumption remains with the defendant throughout the trial of the case unless and until the prosecution proves this allegation beyond a reasonable doubt. The presumption of innocence is not a mere slogan but an essential part of the law that is binding upon you. It places upon the prosecution the duty of proving every material element of this allegation beyond a reasonable doubt. You must not find the defendant guilty upon mere suspicion or upon evidence which only shows that this allegation has been proven by the prosecution. What the law requires before it can be determined that the prosecution has proven this allegation is not suspicion, not probabilities, but proof of this allegation beyond a reasonable doubt. What is a reasonable doubt? It is a doubt in your mind about the facts at issue during this phase of the trial, which arises from the evidence presented or from the lack of evidence, and which is based upon reason and common sense. Each of you must decide individually whether there is or is not such a doubt in your mind after careful and impartial consideration of the evidence. Be mindful, however, that a doubt which has no basis in the evidence presented, or the lack of evidence, or reasonable inferences therefrom, or a doubt which is based upon imagination, suspicion, or mere speculation, or guesswork, is not a reasonable doubt. What is proof beyond a reasonable doubt? If, after consideration of the evidence and the law, you have a reasonable doubt regarding whether the murder in the second degree of Carly Scott by the defendant was especially heinous, atrocious, or cruel, manifesting exceptional depravity, then the prosecution has not proven that the murder in the second degree of Carly Scott by the defendant was especially heinous, atrocious, or cruel, manifesting exceptional depravity beyond a reasonable doubt, and it is your duty to answer no to the question in the interrogatory form that will be provided to you. If, after consideration of the evidence and the law, you do not have a reasonable doubt that the murder in the second degree of Carly Scott by the defendant was especially heinous, atrocious, or cruel, manifesting exceptional depravity, then the prosecution has proved that the murder in the second degree of Carly Scott by the defendant was especially heinous, atrocious, or cruel, manifesting exceptional depravity beyond a reasonable doubt, and it is your duty to answer yes to the question in the interrogatory form that will be provided to you. Instruction number 4. You must consider only the evidence which has been presented to you during this trial, and such inferences therefrom as may be justified by reason and common sense. The prosecution's allegation is a mere formality, and is not to be considered as evidence against the defendant. You must not be influenced at all because the prosecution has made this allegation. This trial is governed by rules. When an attorney believes that the rules require it, it is his or her duty to raise an objection. It is within the province of the trial judge to rule on such objections. During the course of the trial, you have heard counsel make objections. You must not consider objections raised by counsel in your deliberations. Statements or remarks made by counsel are not evidence. You should consider their arguments to you, but you are not bound by their recollections or interpretations of the evidence. You must also disregard any remark I may have made unless the remark was an instruction to you. If I have said or done anything which has suggested to you that I am inclined to favor the claims or positions of any party, or if any expression or statement of mine has seemed to indicate an opinion relating to which witnesses are or are not worthy of belief, or what facts are or are not established, or what inferences should be drawn therefrom, I instruct you to disregard it. You must not be influenced by pity for the defendant or by passion or prejudice against the defendant. Both the prosecution and the defendant have a right to demand, and they do demand and expect, that you will conscientiously and dispassionately consider and weigh all of the evidence and follow these instructions and that you will reach a just decision. Instruction number 5. You must treat all participants in this trial without bias, prejudice, or favoritism based on actual or perceived race, color, ancestry, national origin, ethnicity, sex, gender identity, sexual orientation, marital status, age, disability, religion, socioeconomic status, or political affiliation. Participants in this trial include the parties, attorneys, witnesses, and other jurors. Instruction number 6. You must disregard entirely any matter which the court has ordered stricken. Instruction number 7. You may but are not required to accept as conclusively proved any fact or event which the court has judicially noticed. Instruction number 8. In addition to facts which the court has taken judicial notice of, there are 2 types of evidence. direct evidence such as the testimony of witnesses who assert actual knowledge of a fact, and circumstantial evidence which permits a reasonable inference of the existence of another fact. Facts may be proved by direct or circumstantial evidence or by a combination of both direct evidence and circumstantial evidence. Instruction number 9. While you must consider all of the evidence in determining the facts in this case, this does not mean that you are bound to give every bit of evidence the same weight. You are the sole and exclusive judges of the effect and value of the evidence and of the credibility of the witnesses. Instruction number 10. It is your exclusive right to determine whether and to what extent a witness should be believed and to give weight to his or her testimony accordingly. In evaluating the weight and credibility of a witness's testimony, you may consider the witness's appearance and demeanor, the witness's manner of testifying, the witness's intelligence, the witness's candor or frankness or lack thereof, the witness's interest, if any, in the result of this case, the witness's relation, if any, to a party, the witness's temper, feeling, or bias, if any, has been shown, the witness's means and opportunity of acquiring information, the probability or improbability of the witness's testimony, the extent to which the witness is supported or contradicted by other evidence, the extent to which the witness has made contradictory statements, whether in this hearing or at other times, and all other circumstances surrounding the witness and bearing upon his or her credibility. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause you to discredit such testimony. In weighing the effect of inconsistencies or discrepancies, whether they occur within one witness's testimony or as between different witnesses, consider whether they concern matters of importance or only matters of unimportant detail, and whether they result from innocent error or deliberate falsehood. Instruction number 11. If you find that a witness has deliberately testified falsely to any important fact, or deliberately exaggerated or suppressed any important fact, then you may reject the testimony of that witness, except for those parts which you nevertheless believe to be true. Instruction number 12. You are not bound to decide a fact one way or another just because more witnesses testify on one side than the other. It is testimony that has a convincing force upon you that counts, and the testimony of even a single witness, if believed, can be sufficient to prove a fact. Instruction number 13. The prosecution is not required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence, who may appear to have some knowledge of these events, or to produce all objects or documents mentioned or suggested by the evidence. Instruction number 14. The defendant has no duty or obligation to call any witnesses or produce any evidence. Instruction number 15. The defendant has no duty or obligation to testify, and you must not draw any inference unfavorable to the defendant because he did not testify during the trial, or consider this in any way in your deliberations. Instruction number 16. The state of mind with which a person commits an act, such as intentionally or knowingly, may be proved by circumstantial evidence. While witnesses may see and hear, and thus be able to give direct evidence of what a person does or fails to do, there can be no eyewitness account of the state of mind with which the acts are done or omitted. But what a person does or fails to do may or may not indicate the state of mind with which he does or refrains from doing an act. Instruction number 17. A person acts intentionally with respect to his conduct when it is his conscious object to engage in such conduct. A person acts intentionally with respect to attendant circumstances when he is aware of the existence of such circumstances or believes or hopes that they exist. A person acts intentionally with respect to a result of his conduct when it is his conscious object to cause such a result. Instruction number 18. A person acts knowingly with respect to his conduct when he is aware that his conduct is of that nature. A person acts knowingly with respect to attendant circumstances when he is aware that such circumstances exist. A person acts knowingly with respect to a result of his conduct when he is aware that it is practically certain that his conduct will cause such a result. Instruction number 19. Several times during the trial, I told you that certain evidence was admitted for a particular and limited purpose. When you consider that evidence, you must limit your consideration to that purpose. Instruction number 20. During the trial, items were received into evidence as exhibits. These exhibits will be sent into the jury room with you when you begin to deliberate. Instruction number 21. Training and experience may make a person an expert in a particular field. The law allows that person to state an opinion about matters in that field. Merely because such a witness has expressed an opinion does not mean, however, that you must accept this opinion. It is up to you to decide whether to accept this testimony and how much weight to give it. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. Instruction number 22. As the sole and exclusive judges of the facts and of the credibility of the witnesses, it is your exclusive right to determine whether and to what extent the defendant's out-of-court statements to police is worthy of belief. In evaluating the reliability and trustworthiness of the out-of-court statements, you should consider all of the circumstances surrounding the making of the statements, including the use of deception or coercion to obtain the out-of-court statements. Instruction number 23. The prosecution has alleged that the murder in the second degree of Carly Scott by defendant Stephen N. Capobianco was especially heinous, atrocious, or cruel, manifesting exceptional depravity. Exceptionally heinous, atrocious, or cruel, manifesting exceptional depravity, means a conscienceless or pitiless crime which is unnecessarily torturous to a victim. A murder in the second degree is especially heinous, atrocious, or cruel, manifesting exceptional depravity if the victim suffered unnecessary torture and the person intentionally or knowingly inflicted unnecessary torture on the victim. There are 5 material elements to establish that the murder in the second degree of Carly Scott by the defendant was especially heinous, atrocious, or cruel, manifesting exceptional depravity, each of which the prosecution must prove beyond a reasonable doubt. These 5 elements are: 1, that the defendant was 18 years of age or older at the time of the murder in the second degree of Carly Scott, and 2, that the murder in the second degree of Carly Scott was a conscienceless or pitiless crime, and 3, that the victim suffered unnecessary torture, and 4, that the defendant inflicted unnecessary torture on the victim, to wit Carly Scott, and 5, that the defendant did so intentionally or knowingly as to each of the foregoing elements. Instruction number 24. Unnecessary torture is the infliction of extreme physical or mental suffering beyond that which necessarily accompanies the underlying killing. It encompasses more than the infliction of a fatal injury. Instruction number 25. The decision of the jury regarding whether the murder in the second degree of Carly Scott by the defendant Stephen N. Capobianco was especially heinous, atrocious, or cruel, manifesting exceptional depravity, must represent the considered judgment of each juror, and in order to return a decision, it is necessary that each juror agree thereto. In other words, your decision must be unanimous. Each of you must decide the case for yourself, but it is your duty to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violating your individual judgment. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest belief as to the weight or effect of evidence for the mere purpose of returning a decision on whether the murder in the second degree of Carly Scott by the defendant was especially heinous, atrocious, or cruel, manifesting exceptional depravity. Instruction number 26. You may take such time as you feel is necessary for your deliberations. You may inform the court if you have any questions about or do not understand the court's instructions. When you reach a decision, the foreperson is to sign and date the special interrogatory that will be given to you. Until you are through with your consideration of this case, or you are otherwise excused by the court, it is necessary from this time that you remain together as a body. If you need to communicate with the court, send a note through the bailiff. Please do not attempt to communicate with the court except in writing. During the course of the trial, you have received all of the evidence you may consider to the question on the special interrogatory form. You must not attempt to gather any information on your own which you think might be helpful. Do not engage in any outside reading on any matter having anything to do with this case. Do not refer to dictionaries or other outside sources. Do not visit any places mentioned in the case. Do not in any other way try to learn about the case outside the courtroom. During your recesses from deliberations, when you are released to go home in the evening, you must not discuss this case with anyone or permit anyone to discuss this case with you. You must not read or listen to news accounts about this case if there are any. You must not discuss this case with any person other than your fellow jurors. You must not reveal to the court or to any other person how the jury stands, numerically or otherwise, until you have reached a unanimous decision and it has been received by the court. After your decision has been reached and your foreperson has signed and dated the special interrogatory form, you will notify the bailiff and court will be reconvened to receive the decision. Instruction number 27. You have been allowed to take notes during the presentation of this case. When you leave the courtroom to commence deliberations of this case, you must follow some important rules with regard to notes. 1. Notes are for your own personal reference to assist you in refreshing your memory of the evidence. Keep your notes to yourself and do not show or read them to any other juror. 2. You must not give your notes precedence over your independent recollection of the evidence. If there is an inconsistency between your memory of the evidence and your notes, treat your memory of the evidence as controlling and accurate. 3. You must not give certain evidence emphasis simply because it appears in your notes. Do not assume that because something appears in your notes that it necessarily took place in court. 4. Some of you have not taken notes. If you have not taken notes, you should rely on your own independent recollection of the proceedings. Jurors who do not take notes should rely on their own memory of the evidence and should not be influenced by the fact that another juror took notes. Notes are not entitled to any greater weight than the memory or impression of each juror as to what the testimony may have been. 5. Anytime you leave the jury room during deliberations, leave your notes face down on the table. 6. If you go home overnight without reaching a verdict, the court will collect the notes and return them to you at the start of the next day. 7. After you have reached a verdict, your notes will be collected by the court and destroyed. Instruction number 28. You may bring in only one of the following answers to the following question. Has the prosecution proved, beyond a reasonable doubt, that the murder in the second degree of Carly Scott by the defendant, Stephen N. Capobianco, was especially heinous, atrocious, or cruel, manifesting exceptional depravity? 1, yes, or 2, no. Your answer to this question must be unanimous. After you have reached a decision and your foreperson has signed and dated the special interrogatory, you will notify the bailiff and court will be reconvened to receive your decision. Now what we're going to do now, ladies and gentlemen, is proceed to the closing arguments as concerning this phase of the trial, and we'll follow the same procedure. In other words, the prosecution will present its closing argument first, followed by the defense if the defense desires to present a closing argument, and then followed by a rebuttal argument by the prosecution. Please keep in mind during the closing arguments of the parties that the statements or remarks made by counsel are not evidence. You should rely on their arguments to you, You should consider their arguments to you, but you are not bound by their recollections or interpretations of the evidence. All right. Mr. Rivera, you ready to proceed?
Yes, sir.
All right, you may proceed.
Thank you. May it please the court. Counsel. 7 months ago, none of you expected to be in the presence of a man who would commit murder. In fact, a man who did commit murder. And not just a murder, but a murder involving a young woman who was 5 months pregnant. And not only were we all in his presence, but we've been in the same room with him day after day, week after week, month after month, for over half the calendar year of 2016. During that time, ladies and gentlemen, we did learn about the defendant, but we also learned about Charlie Scott. In fact, we learned a lot about Charlie Scott. She was 27 years old. We learned what kind of person she was. She was loving. She was caring. She was devoted. She was motherly. We also learned what kind of person, or what type of person the defendant is. He's manipulative. He's deceitful. He is not devoted. He is selfish. And he's a man without a conscience. And that brings us to the second phase of this trial. Now that he's been found guilty of committing murder in the second degree, you no longer have to make that determination who killed Charlie Scott. That's already been determined. So the second phase of trial, the only thing for you to consider at this point, and the court did redo that instruction, the only question before you folks is whether the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. That's the only question before you. And right now, you might be wondering, why weren't we told, why weren't you told that there's a second phase to this trial? Because at the very onset, you were already told that what the initial charge of complaint against the defendant was, which is murder in the second degree. And that's a fair question. Why weren't you told that? Well, the reason is that the defendant has a constitutional right to due process. And due process requires, before we reach to the second phase that we're in now, defendant has to be found guilty of the first step of murder in the second degree. That's what it requires, and that's why you were told, so that you won't make any, or so there may be no incorrect assumptions made if you were told that there's two separate phases to this case. And now that you know there is, we're at that stage at this point. If I could have the all turn to instruction number 23. And that's the instruction that will give you or provides you information on what it means to commit a murder that is especially heinous, atrocious, or cruel, manifesting exceptional depravity. And if you can turn to the bottom part of the first page of instruction 23, there are 5 elements. These 5 elements are actually 5 requirements or definitions of that phrase. Okay? And some of these elements are not in dispute. For example, the first element, that the defendant was 18 years of age or older at the time of the murder in the second degree of Carly Scott, also known as Charlie Scott. Well, the defendant himself, during his interview with Detective Liu back in February of 2014, made it clear that he was born on October 6, 1989. That made him 24 years old at that time, 3 years younger than Charlie Scott. She was 27. That's not in dispute. Number 2, that the murder in the second degree of Carly Scott was a conscienceless or pitiless crime. The state would submit to you that that is not in dispute. What is in dispute are elements 3, 4, and 5. Number 3 reads that the victim suffered unnecessary torture. That's 3. And number 4, that the defendant inflicted unnecessary torture on the victim, to wit, Carly Scott. And number 5, that the defendant did so intentionally or knowingly as to each of the foregoing elements. So he did this intentionally and knowingly. That's the definition, and that's the instruction that the court has read to you, and that's the instruction that you must follow. And in order to get into that, I would want to start, the state wants to start backwards, starting with element number 5, that the defendant did so intentionally or knowingly. What was his intent? What did he intend to do? What did he want to do? Well, to get to that, we need to go far back as October of 2013, with that visit to the Apoplo of Planned Parenthood. And that will give us a glimpse of what his intent was. If you will recall, as he sat there, and Linda came into the room, because the other counselor had called her into the room, and she first saw Charlie and the defendant sitting there. And she wanted to ask about the pregnancy. And some of the defendant's first words was, he wasn't with her, meaning Charlie. He indicated to Charlie, and he told Ms. Popolo, I'm not with her. At first glimpse, one would think, okay, so he's telling Ms. Popolo that he's not with her. What's interesting is she didn't ask him that. She didn't ask him, are you folks together? She just wanted to know who the father was. She wanted to know about the baby. But what she saw provided a mountain of information. Because when he said those words, and she looked at Charlie, if you recall what she saw a pained expression. And she described that as emotional pain. And she also could tell by that emotional pain that Charlie was still in love with the father of her baby. But that pain was real. She felt it, she saw it. And what that tells us, ladies and gentlemen, when the defendant told Linda those words weren't only meant for Linda's ears, Linda Popolo's ears. They're also meant for Charlie Scott. He didn't have to inform Linda that because Sunshine Linda didn't ask him whether they were together. He wanted to remind Charlie Scott that they were not together. He wanted to remind Charlie Scott that they were there for one purpose, and that was to get an abortion. He wanted to remind Charlie Scott that there was no chance they were going to be together. Hence, that emotional pain she suffered right there in the room. So one can imagine if he is willing to cause Charlie that type of pain, that type of suffering in front of a complete stranger in public, one can imagine what he's likely to do when he is in a rage, in a dark and secluded forest with no one around except Charlie, and he's armed with a knife. Once the defendant was able to lure Charlie Scott to the Wailuku area, he followed through with his plan to not only kill her, but to make Charlie Scott suffer. Killing Charlie Scott was not enough for this man. Again, he's a man without a conscience. And how do we know that killing Charlie Scott was not enough for the defendant? Well, we know this because one only has to look at the black skirt that Charlie wore that night. And one only has to look at the multiple stab wounds that are directed at the abdomen portion of the skirt, Charlie Scott's wound. Because if he only wanted to kill her, stabbing her in the chest would have done it. And stabbing Charlie Scott in the chest would have also terminated her pregnancy. But that wasn't enough. They stabbed wounds through her skirt. Speaks volumes to you. The state mentioned this earlier in the first phase in its closing arguments. So why go after Charlie's wound? Why go after the baby? Why attack the unborn when it would never be born with the mother's death? And that answer becomes pretty obvious. Because in order to hurt Charlie and to make her suffer the most, he wanted her to be conscious, and he wanted to know that he was going after the one thing she loved the most. And that was her child, her unborn child. As he plunged that knife time and time again into her womb, it's almost unimaginable how she suffered, what that torture would have caused her. Both mental pain and certainly emotional and psychological anguish. What could she do? This mother-to-be would give her life. There's no question she would have given her life for that child. But at that point in time, because he wanted to make her suffer and realize that she crossed him and he was going to make her pay for that. At that point in time, that 5-month-old fetus was prolonging Charlie's life. Her baby was protecting her. What kind of suffering is that for a mother to be, to witness that? No doubt there's physical suffering, but the state would submit that the mental and psychological suffering would have been even greater than any physical suffering that any human being could endure. Ladies and gentlemen, Charlie was not only murdered, but also suffered an unnecessary torture that is almost beyond comprehension. The man who was responsible for this depravity is still in court today, and based on the evidence, must be held accountable for his actions.
I'm going to object to that last comment. Must be held accountable. It's just for passion and prejudice.
And it's based on the evidence.
The last sentence begins with, and based on the evidence. I will therefore overrule the objection.
Thank you.
All right, Mr. O'Toole, you may proceed.
Let me just start off by acknowledging your verdict and submitting to you that this argument is focused on this part of the proceeding at this point. This argument goes to the law and evidence or lack thereof relating to the alleged aggravated circumstances which you will be receiving a question about. I submit to you that the law is very instructive under the circumstances, and that an honest application of these instructions and the law to the evidence in this case should result in a negative answer to the question being presented to you. Let me start off with the jury instructions in the law relating to these allegations. Jury instructions 3 and 4 bring you right back to the appropriate starting point for this part of the trial and for your consideration of this part. You must presume the defendant innocent of this allegation against him. This presumption remains with the defendant throughout the trial of the case unless and until the prosecution proves this allegation beyond a reasonable doubt. It takes you back to the burden of the state, and that is that it places upon the prosecution the duty of proving every material element of this allegation beyond a reasonable doubt. And just let me touch on something really brief right here. When we're talking about material elements and you have an instruction that has, for example, 5 material elements and they're connected with ands, that means it's conjunctive. It means you need to find both. It's not or, it's and. You can't check that all of the elements are satisfied unless all of them are checked off. It's not an or in between them. It's an and. What the law requires before it can be determined that the prosecution has proven this allegation is not suspicion, not probabilities, but proof of this allegation beyond a reasonable doubt. I want to highlight one of the more important provisions in jury instruction number 4 as it applies to this part of the trial. And it presents itself on the second page of that jury instruction. And what that tells you is that you must not be influenced by pity for the defendant or by passion or prejudice against the defendant. Look, ladies and gentlemen, as an implication of your initial verdict, I get that you believe that I'm the one trying to fool you as to what happened to Charlie Scott back in 2014. To compound matters for me as far as this argument is concerned, I'd be lying if I told you I have a clue as to what you 12 determined to be the manner of death in this case. I say this because I submit to you the state seemed to throw to you a few proposed manners of death in this case, at least in its closing argument for the first part of this trial. And I obviously don't have the benefit of having heard your deliberations. I will say this. If you honestly believe beyond a reasonable doubt that Charlie Scott died from, among other things, Stephen sitting there with a serrated kitchen knife, sawing into her, making parallel lines by happenstance in her jawbone, if you honestly believe that Stephen dismembered Charlie, in particular her jawbone, because she had a mouth on her, as it was somehow suggested to you by the state, and if you honestly believe, as the state argued, that the lower part of Charlie's right jawbone is speaking to you at this point, then I honestly don't expect you to listen to or understand anything I say here today. I bring this up now because, again, jury instruction number 4 instructs you pretty clearly. You must not be influenced by pity for the defendant or by passion or prejudice against the defendant. Now, ladies and gentlemen, if Mr. Rivera stays true to form, when I'm done with this argument, he will be dramatically and passionately trying to tell you how those lower jawbones, attacked so violently with a serrated knife because Charlie had such a mouth on her, is now, ironically, the evidence speaking to you to find Stephen guilty here again.
Could I get some proper argument? It's also not accurate.
This being closing argument, the objection is overruled. Again, a jury is reminded that the jury is not bound by the recollections or interpretations of the evidence as presented by counsel. You may proceed.
Regarding arguments, well, I mean, what was it today? That the, let me get to that. Now, if Mr. Rivera is going to argue about jawbones talking to you, I really don't have any arguments against that. Regarding arguments based on passion and prejudice against Stephen, I don't know where to even begin against an argument like that. For sake of this argument, I'm going to address the only possible manner of death I'm guessing was attributed to Stephen. Before getting into these facts, though, I want to continue highlighting the most relevant jury instructions. And that is jury instruction 23 and jury instruction 24. Those are the specific instructions relative to your task at this point. As I suggested to you, the 5 elements in jury instruction 23 are joined by ands, and you cannot find that the state has satisfied its burden unless all of those elements are satisfied. And I'll submit to you that for the first time in this trial, the prosecutor's hypothetical back in jury selection as to that whole thing about if you're wearing a shirt, pants, and shoes, that hypothetical is now coming into play. And I submit to you that it's going to be a more difficult task than your last task because it requires a specific manner of death to make a finding here. The checklist is pretty clear. There's 5 elements. But as your need to evaluate these 5 elements progresses, definitions containing more elements or what amount to more elements apply. I submit to you that your task will be centered around the element number 3 in jury instruction number 23, as well as the elements that define unnecessary torture in jury instruction number 24. Before applying all of the instructions to the evidence of this case, let me just highlight. You just determined that Stephen killed Charlie in your initial deliberations, either intentionally or knowingly. If it's not obvious, I'll point out something our state's highest court has noted in the context of your pending consideration. And that is that all murders are arguably heinous, atrocious, and cruel. And that is what you have found in your initial verdict. The consideration now relates to the issue of whether there was any torture evidence and whether any such torture was unnecessary. Again, above and beyond that which would accompany the killing. And I'll just acknowledge right now, I'm sure, well, look, ladies and gentlemen, as much as we all hate that Charlie was pregnant when this happened to her, there is absolutely no evidence whatsoever in this trial that Stephen intended to or knowingly tortured Charlie before killing her however you determine he killed her. To use the only sensible proposed manner of death as an example, even if the manner of death was determined to be multiple stab wounds to the womb of Charlie's unborn child, it is against the law and the instructions to find that the state has met its burden. As applied to this case, and as counterintuitive as it may seem without further thought, this is what it comes down to. The more stab wounds, the quicker the onset of death. The quicker the onset of death, the less the suffering. Now, you guys may not like that, but that is common sense and reason. This is the worst that is legitimately, possibly evidenced in this case. Again, if you actually believe that Stephen somehow kept her alive and sat there and cut her jaw off and cut it up with the serrated knife, then I have nothing reasonable to argue to you. Unnecessary torture under the circumstances would be a stab wound to the victim, leading her to suffer death, an elongated death. And it's amazing how Mr. Rivera is willing to ignore the facts that he proposed as evidence, because he's over here telling you that if he wanted to kill her, he would have stabbed her in her chest area. Well, what about all of those supposed stab wounds evidenced by the bra? Look, ladies and gentlemen, let me just confront the elephant in the room as it relates to the facts of the case, as they relate to this part of your considerations. The victim was pregnant. The proposed motive by the state was that the pregnancy was the motive of the killing. When it comes to tapping into your passions and prejudices against him, the prosecutors could not have more of a sympathetic victim. And at this point, I would submit that you couldn't have a more sympathetic jury with a pregnant juror on the panel.
There's an objection. That's highly prejudicial.
The objection is...
And it needs to be stricken, and counsel needs to be cautioned at this point.
Over what?
The objection is sustained, and the argument, that last argument, is stricken.
By not acknowledging my audience?
The court has ruled. Let's proceed.
Fact is, I'm sure it's like holding a blank check over there for the state. Sounds like they get to ask for anything at this point. Just throw it up in the air.
Objection, improper argument, Your Honor.
The objection is sustained.
Move to strike that as well.
Granted.
All I can possibly ask at this point is for you folks to apply the law honestly. Ultimately, asking yourself whether any torture whatsoever was evidenced by the state, much less unnecessary torture. Of course, Charlie suffered, much like anyone else suffers, both mentally and physically during the onset of death. In the case of murder, the more of a surprise the attack, the quicker the onset of death, the less suffering. Isn't that what the state is saying happened? She was lured out there, surprised with an attack, and then was stabbed multiply. That evidences, if what has been evidenced here is that the perpetrator intended to perpetrate the onset of death, not the unnecessary suffering of the victim. And if you folks honestly believe that evidence presented by Linda Popolo is actually relevant at this point in the trial, I got nothing to say. This consideration is about is about you folks deciding whether Charlie Scott was kept alive to be tortured. I just submit to you, in this trial, there's been absolutely no evidence to that.
Right, at this time, ladies and gentlemen, the prosecution will be given the opportunity to present the prosecution's rebuttal argument. You may proceed, Mr. Rivera.
The deep cut marks in Charlie Scott's bra supports the state's argument that the defendant intended not to just kill her, but to make her pay and suffer for not following through with his plan. Why is that? Because if he only wanted to kill her, all you would see would be the cut marks in the bra. But he did more than that. That wasn't enough for him. And the state would argue too, the kind of person he is the kind of person with such a depraved mind that killing was never going to be enough for him. If he's going to go through all that effort, he's going to make sure she realized what he was doing to her. And we know that by some more of his comments he made. When he told John Palaki, this is months after he committed the murder. When he told John Palaki, after telling him a story and ending with the words, "I have to keep myself from killing someone again," that wasn't just a slip-up. That wasn't just, oh, did I just say that? That was the defendant's way of boasting, of letting another person know that he was proud of what he did. Because the defendant's warped and depraved mind, while the rest of humanity knows that it's such a cowardly act that he did, in the defendant's mind, he's thinking he accomplished something that no one would dare imagine. Make a pregnant woman suffer who didn't listen to you. Make her suffer and pay before you killed her. And you only get this when you listen to the testimony of all those who know the defendant, what kind of person he is. Only a man without a conscience. Only a man who is so depraved. Only a man who is so selfish.
I'm going to object. How is this not arguing about prejudice against the defendant and passion and prejudice? That's all this is. Cite some evidence.
Excuse me. The objection is sustained.
Move to strike.
Motion to strike is granted.
Based on that statement, ladies and gentlemen, and the statements he made, he is that kind of person that would cause a woman to suffer the way Charlie did.
So I'm going to object. I think counsel just based his argument on something that was stricken.
The objection is sustained. And the
Move
court
to
will
strike
order
then.
the argument stricken. Proceed.
Why can you conclude he has no conscience? Easily. You listen to the 3 tapes back in when you were deliberating. You listen to how confident, how cocky, how arrogant, how so self-assured he is. And he's being questioned by multiple
So I'm going to again object. How is this rebuttal? This is character
The
arguments.
objection is sustained.
Judge, this goes into what his intention is. Well, how could that be not considered
As it-
relevant.
Any dispute
Excuse me.
is suffering.
I'm ruling, I'm going to sustain the objection. The argument should be focused on the elements related to what needs to be proved with respect to the.
Right, and what the state is arguing is it takes a certain kind of person to cause that type of suffering to the
The court
state.
is ruled. Please proceed.
Well, the state has to,
And I'll strike the last argument of the prosecution. Proceed.
that wasn't asked for, Your Honor.
I did ask.
So the court's ruled on it. Proceed.
The state has to prove that the defendant intentionally and knowingly caused Charlie Scott to suffer. So ask yourself, what kind of person would intentionally and knowingly cause a woman who's 5 months pregnant to suffer like Charlie Scott did? And based on the evidence and by all accounts of the testimony, you can conclude what kind of person would do that. And he's in the room with us today.
So I'll object to that.
How
Same
can
grounds.
that be objectionable?
Is he's again going to the same
excuse me.
basis
Excuse me. I'll sustain the objection.
and move to strike.
The motion to strike is granted.
At the beginning of this trial, ladies and gentlemen, during the state's opening statement, the first words out of the state's mouth is, "Down this path, there is horror." It's time to end the horror.
So I'm going to object. This is passion prejudice, not rebuttal. Beyond the scope. Doing it again.
The objection is overruled.
It's time to end this horror. Based on the evidence presented to you, make the defendant take responsibility for what he did.
So I'm going to object to that as inflammatory. That is passion, prejudice, and inflaming the jury to action.
The objection is overruled. All right. All right. All right, ladies and gentlemen, we have concluded the court's reading instructions of law and the arguments of the parties relative to this phase of the trial. What will occur in a moment is I'll be turning the special interrogatory over to the bailiff. And just for your information, this is what it looks like. Somewhat similar to verdict form, except that it has the question that I've already read to you. And then there's a blank for yes and a blank for no. So please keep in mind that your answer to this question must be unanimous. In other words, all 12 must answer yes, or all 12 must answer no. All right. And the question is set forth in the special interrogatory form. It's the same question that I read to you in instruction number 28. All right. So at this time, I'm going to instruct the bailiff to approach and take possession of the original of the special interrogatory form. The record will reflect that the bailiff has done so. All right, ladies and gentlemen, similar to the initial phase of the trial, you are about to begin your deliberations. I'm going to be, with respect to the alternates, we're going to follow the same procedure that we followed in the first phase of the trial. So please keep in mind that all of my cautionary instructions remain in effect. All right, and again, I thank you for your cooperation throughout the stage of the proceedings. Ladies and gentlemen, you'll go into the jury room. I've told you that you, after we received the initial verdict, I told you that you cannot discuss this case with anyone, even among yourselves, and that I would let you know when you can do that. So as in this phase of the trial, when you get into the jury room, you can commence your deliberations. In other words, begin to discuss the case amongst yourselves. Keep in mind that all 12 jurors must be present when deliberating. And when you have reached a decision which must be unanimous, your bailiff, I'm so sorry, your foreperson will sign, date, and fill out the special interrogatory that you have, and then you'll send us a communication indicating that an answer, which must be unanimous, has been reached. In other words, a decision has been reached as to this phase of the trial. And the court will be reconvened to receive your decision. All right. Thank you very much, ladies and gentlemen. And unless there's something else at this time, Mr. Rivera?
See, there's nothing further.
Mr. Alpo?
Nothing for defense.
All right. Then you may commence your deliberations, ladies and gentlemen.